Hello, I'm Richard Wish, a Professor of Competition Law at King's College London, and I am the presenter of this ICN module on leniency programs and leniency policy. In the course of what follows, you will also be hearing from officials from a number of competition authorities around the world, and you will also see some reenactments of hypothetical cartel meetings. Let's begin with a discussion of what we mean by leniency policy and a leniency program. Leniency is a general term that refers to a system in which a firm that is in a cartel receives a total or partial exoneration from the penalty that would otherwise have been imposed upon it in return for reporting its cartel membership to a competition authority. It's probably sensible at the outset to explain that different terminology is used in different parts of the world when discussing this subject. We often hear about the so-called whistleblower. This typically refers to the first firm that reports the existence of a cartel to a competition authority. The whistleblower is often totally exonerated from any penalty. This is sometimes referred to as an amnesty. That's the expression that is particularly used in the United States. In Europe, we tend to prefer the expression immunity, but these two words, amnesty and immunity, for these purposes really mean the same thing. In many countries, penalties may be reduced for firms that provide useful evidence to a competition authority about a particular cartel, even though they were not the actual whistleblower, that is to say, the first firm to expose the existence of the cartel. Such firms can be said to receive leniency in the sense of a smaller penalty than would otherwise have been the case. Just to be clear, in this video we will discuss both immunity, the total exoneration from penalties, and leniency in the sense of lower penalties than would otherwise have been imposed. However, when we talk about a leniency program or about leniency policy, we are referring both to total and to partial exoneration from penalties. It is important at the outset to establish what precisely the key cornerstones of an efficient leniency program are. There's fairly widespread agreement about this nowadays. The first is that there should be severe sanctions for members of a cartel who do not report them to a competition authority. The second is that it should be abundantly clear that there is a high degree of likelihood that participants in cartels who do not report them to a competition authority will be discovered and punished. The third requirement is that the leniency program itself should be transparent and predictable, so that firms understand precisely how the process of making an application to a competition authority will work. What are the benefits of implementing a leniency policy? We have to remember it's not easy for competition authorities to detect cartels. Firms that enter into cartels, for example, price fixing or sharing out markets, often know that what they are doing is illegal and that they should take precautions in order to prevent detection. An effective leniency policy provides incentives to firms that are in cartels to go to the competition authority and provide details of what they have been doing. This means that the competition authority gets first-hand, direct, insider evidence of what has been taking place, while the firm in question gets a total or partial reduction in its penalty. This is a win-win situation if it means that the competition authority can punish the other members of the cartel and the leniency application gets a total or partial reprieve. It is worth adding that the very fact of there being a leniency policy in place may in itself destabilize the cartel. In the end, if the leniency policy works well in practice, this will mean that the competition authority will detect and punish more cartels. The deterrent effect of the law is increased because it can be demonstrated that cartels will be detected and punished, and this leads to greater competition, or to put the point another way, to fewer cartels, with all the benefits that competition brings: lower prices, better service, more innovation, and greater choice for consumers. Let's take a look now at an imaginary cartel meeting.
So we can get started in a few minutes. I'm sure we should be late, but we need to get this meeting started. For me next week. I need it at the end of the month. So I'm sure he'll be here any minute. We'll give him about 5 minutes and we'll get started. Ah, there he is. Peter, glad you could make it. Thanks for coming.
Nice to see you.
Great, please come in.
Sorry guys, my plane was so late.
Please, don't worry. Thank you all for your patience. Let's get started. I spoke to Jeff in Johannesburg recently, and it looks very worrying. The prices of raw materials are rising again, and we're struggling with excess capacity.
That's really bad.
Yes, and on top of this, our customers are playing us one against the other to get the best prices. We are really feeling the squeeze.
I don't think any of us can afford to play that game any longer. I think it's time we go back and take a look at our previous arrangement.
Could you be more precise?
We all raise our prices globally, and in conjunction with that, we stop approaching one another's clients and stick to our own territory. I thought we had an agreement on this. It was working, but then we started stealing customers from one another.
Do you have any concrete figures?
Yes. In order to retain our current profit margin, we need to raise the end price by at least an average of 3%. Does everyone agree? If so, then remember this only works if we're disciplined about not poaching one another's clients. So my proposal would be to go for a raise of 2% in Europe, 4% in Asia, 3% in the Americas, and 2% in Africa. If we're all agreed, then let's start next month. In order to not raise suspicion, I suggest that we did it like we did last time. I'll go first. You guys follow 2 weeks later. We have to stay in touch, so let's meet again next month and see if the arrangement's working. In case of any questions, call each other on your private mobiles. Do not email. Better to avoid leaving any trace of this discussion or arrangement.
No, everything is okay. I'm just a bit concerned because Alex was suggesting that we all raise the prices again. Yeah, pretty much straight away. Similar to what we did before. I have to admit that I'm not really happy with this arrangement. It's always very risky. I think I have to give them lawyers a call. Anyway, I'll be back in time tomorrow. Yes, promised. Kiss, kiss.
Obviously, it's a very major step for a firm to take to decide to blow the whistle to a competition authority. It will do so taking into account all the various pros and cons, the most obvious pro being that the whistleblower can hope to earn total immunity from any penalty.
Is it illegal?
Yes, you might have a serious problem here. What you have described as a cartel, which is against competition laws. And competition agencies around the world may soon be looking into your practices. You may be facing quite a hefty fine, not to mention the possibility of an investigation being launched against you personally. And depending on the scope of the cartel, you may even face a jail sentence.
But I wasn't the instigator.
But that is of no consequences to the authorities. You are a participant in a cartel, and that is enough.
Well, maybe things got a bit out of control. So what would you suggest I can do now?
We would need to establish which jurisdictions the cartel involves, and in that way, which authorities may be interested in its investigations. In the meantime, you could apply for leniency, which would lead to a reduction in fine. And if you are the first member in the cartel to apply, you may get full immunity from fines. A decision on the benefits to apply for would, however, have to be made by your company as quickly as possible, because time is really working against you on this.
In order to qualify for immunity, it is essential for the firm in question to be the first to pass through the door of the competition authority. The second is that it must offer complete and genuine cooperation throughout the process. It's worth adding one other point, however. In some jurisdictions, a firm that coerced others into entering into the cartel, or who acted as the ringleader of the cartel, may not be entitled to immunity at all.
So the EU leniency regime was introduced in 1996 and subsequently amended and improved in 2002 and 2006. Today, the conditions for granting immunity from fines are clearly defined in a Commission notice from 2006, the so-called leniency notice. The leniency notice mentioned that in order to obtain immunity, the leniency applicant has to first be the first undertaking to submit information and evidence about a cartel affecting the EU. Secondly, provide information that either allows the Commission to carry out targeted inspection in connection with the cartel, or allows the Commission to prove an infringement of EU cartel legislation. Thirdly, disclose its own participation in the cartel. It is highly important for cartelists to be first through the door to cooperate with the Commission, since companies further in the queue can only receive reduction of their fines, no full immunity from fines. Experience has shown that granting full immunity only to the first one may indeed create a dynamic which destabilizes cartels and creates a race among cartelists to disclose their conduct to enforcers. This is also reflected in the success of the Commission leniency regime, with an important part of the investigation being triggered by immunity applications. Before going a bit more into the different scenarios for immunity and the condition to be met in order to qualify for such immunity, it should be underlined that the immunity provided by the Commission covers corporate administrative sanction. This is normal, since it is the only type of sanction the Commission can impose. The Commission leniency program contains two different evidential thresholds for granting immunity, depending on the timing of the application, which is crucial. Immunity can be granted if the cartelist provides insider information on a cartel at a time where the Commission does not yet have sufficient information to launch inspection. In that scenario, the immunity applicant should provide the Commission with information that allows it to carry out what we call a targeted inspection, meaning precise information is being given as to what to look for and where and to whom. According to the notice, this is an ex-ante assessment. This means that it is irrelevant whether the inspection following the application will be successful or whether an inspection will be carried out at all. The assessment will be made exclusively on the basis of the type and quality of the information submitted by the applicant. However, the applicant should at the same time not take any measures that could jeopardize the inspection when preparing its immunity application. The Commission services have the practice of discussing with an applicant the collection and submission of information and evidence. In such discussion, the applicants are able to raise any queries they have, for instance, on the immunity threshold, but also on measures they intend to take to collect evidence which may tip off the other cartelists. After inspection, immunity can also be granted after the Commission has already carried out an inspection concerning the alleged cartel, where the Commission has sufficient evidence in its possession to do so. In this case, the applicant needs to submit information and evidence which will enable the Commission to find the infringement. The threshold for such finding is high and corresponds to the threshold required for the Commission to be able to adopt an infringement decision. Consequently, it is higher, much higher, than the threshold for immunity in the pre-inspection situation. In practice, immunity is normally granted under the first scenario. That means before the Commission have begun.
So we now know that in order to qualify for immunity, a firm must be the first to enter through the door of the competition authority. We've also heard that, for example, in the European Union, it is essential for that firm to provide the Commission with evidence that enables it to launch an investigation or to adopt an infringement decision. We have also heard that leniency applicants must comply with a number of other obligations. One of these is the provision of evidence. How exactly the evidence is to be provided may differ from one country to another, but we can identify some common threads.
The question about information an individual must submit to authority is a very interesting issue faced by the authorities around the world. The question is interesting because often the applicant and the lawyers does not have complete information regarding the conduct at the time of the filing. Otherwise, they must act with diligence and speed to ensure, first, that they will obtain the marker, then to the maintenance of the marker, providing the information required, and finally to sign the agreement. So what then submit to the authority? Once the information is available, should be immediately referred to the authority, even if there is still some doubts about the relevance to the case. So it's good to give to the authorities the details that were the most important details taken in order by the companies when it decides to do a cartel. Information such as what product and market was the target of the conduct, which companies or competitors were involved in the conduct, who attended the meetings or who was responsible for contacting other companies, what are the benefits of the cartel, what are the penalties for companies who violate the agreement, who was responsible for monitoring compliance and warn other companies for non-compliance with the cartel, what is the story of the conduct. Once the information is reported, it's crucial that the applicant has means to prove what he said. So, how to prove it? By giving out to the authority written reports about the agreement, meeting files, evidence of the occurrence of the meeting, such as restaurant reservations, travel services account, notebooks, business cards, or evidence about the conversations and the decisions made by cartel, like records of calls, testimonials, and etc.
Even after a firm has been granted conditional immunity, it must continue to offer complete and genuine cooperation. It is not sufficient simply to blow the whistle and then to sit back and do nothing further. This is a very important point from the competition authority's perspective.
Once an application for immunity is made, it may be conditionally granted subject to the full cooperation of the applicant during the investigation and prosecution of the cartel. Final immunity is only granted at the end of these proceedings. It is important that a relationship of trust be established between an immunity applicant and the competition authority, especially after the granting of the conditional immunity. Remember, cooperation itself is often undefined. The immunity applicant is expected to provide honest and expeditious cooperation. Cooperation may manifest itself in many ways, and there can be no exhaustive list. Each case must therefore be determined on its own merits and based on the requirements of each national jurisdiction. Let me now flag the most important elements which are largely universal. The most important rule of thumb is that the immunity applicant must refrain from any conduct that may prejudice the investigation and prosecution of the cartel. And when in doubt, it must consult the competition authority. This means that, amongst other things, the applicant must not inform any third parties, including other cartel members, about the immunity application. In case the applicant is obliged to report to other bodies, for an example, if disclosure is mandated by the stock exchange, the applicant must advise the competition authority of this requirement. The competition authority may, at the beginning, oblige the applicant to cease the cartel conduct immediately, or may allow further cartel participation in case such discontinuation could tip off other cartelists. In order for it to fulfill its obligations, the applicant must ensure the full cooperation of its employees throughout the process. The immunity applicant must not destroy, falsify, or conceal information, evidence, and documents relevant to the cartel activity. The immunity applicant must not make misrepresentations concerning the material facts of the cartel activity or act dishonestly. Whilst each competition authority may have a slightly different approach to the subject of continuous cooperation, there are some practical indicators of cooperation, namely, attending meetings and interviews with the competition authority, submitting statements, evidence, documents, and information, decoding and explaining shortcuts, acronyms, and encryptions which may have been used by the cartel members, acceding to the request for supplementary evidence, documents, and information, conducting its own internal investigations and reporting the findings to the competition authority, making witnesses available and tracing witnesses that may have since left their employment, and providing truthful testimony during the investigation and proceedings. In conclusion, the most important duty that the applicant has is to provide cooperation to the best of its ability in good faith.
When establishing a leniency program, it is important to establish sensible and effective substantive rules, for example, on the type of evidence to be provided and the need for complete and genuine cooperation. However, it is also important to ensure that the procedural aspects of the leniency program are also thought through very carefully. Potential leniency applications need to be absolutely clear about the procedures to be followed. From a competition authority's point of view, it's necessary to consider whether to establish a system of markers, and if so, how such markers can be perfected. Another consideration is whether firms should be permitted to make hypothetical applications about possible cartels. Another issue is the form in which a leniency application should be made, and specifically whether it should be made in writing or orally.
I'd like to explain some common immunity or leniency application procedures. Firstly, hypothetical applications. Many agencies, including the ACCC, encourage people to approach the agency on a hypothetical basis. In this situation, people can contact the agency and inquire about whether, if a cartel existed, they might be able to apply for immunity in relation to that cartel. Agencies don't confirm or deny the existence of any investigation into cartel conduct, but will advise prospective applicants if a first-in marker is available for particular cartel conduct. Most agencies use a marker system. A marker allows a limited amount of time for an applicant to gather the information necessary to demonstrate that they satisfy the requirements for conditional immunity. As long as a person holds the marker for particular cartel conduct, no other person involved in the same cartel will be allowed to take the person's place in the immunity queue, even one who is able to satisfy all conditions immediately. This means that it's not necessary for the person to have assembled a complete record of the cartel conduct to hold first place in the queue. After a marker, an application for conditional immunity or leniency is made. If an applicant decides to lodge a full application for immunity, the grant of full and ongoing immunity may be conditional on an applicant, firstly, being first in, secondly, providing full disclosure and cooperation, and next, using their best endeavours to ensure that all relevant directors, officers and employees cooperate. And finally, not having coerced others to participate in the cartel or having been the clear leader of the cartel. In summary, these are the common procedural steps in dealing with leniency or immunity. Firstly, approach the agency and request a marker. Secondly, lodge a formal application for immunity within the time required. Next, the application will be assessed by the agency. And then, in the case of jurisdictions with a separate criminal prosecutor, the agency will often make a recommendation to the prosecutor. Next, a decision to grant or deny an application is made and communicated to the applicant.
So, now we can sum up the requirements that a firm must fulfil if it is to apply for immunity. The first is that it must be the first through the door of the competition authority. The second is that it must provide complete and genuine cooperation throughout the process. The third is that it must provide the competition authority with the evidence that it needs for its purposes. Obviously, when a firm is considering whether to make a leniency application, it will be heavily influenced by the sanctions that could be imposed upon it if it's found to have infringed the law. The more serious the sanctions, the greater the incentive to blow the whistle. Sanctions may vary from one jurisdiction to another, and that in itself can affect the content of the leniency programme. Let's take a look at the position in Australia. Then we'll go on and see what happens in the United States.
I'd like to talk to you today about three things: civil and criminal sanctions that apply for breaches of cartel laws in Australia, the ways individuals and corporations can get immunity from prosecution, and how we deal with employee cooperation with cartel investigations. Firstly, I'll explain what criminal and civil sanctions can be imposed on individuals in Australia. Individuals and corporations face civil and criminal liability for their involvement in cartel conduct in markets affecting Australians, Australian businesses and Australian consumers. For individuals, the criminal cartel offence is punishable by imprisonment of up to 10 years and or fines of up to 220,000 Australian dollars per contravention. Under the civil prohibition, individuals may be liable for a pecuniary penalty of $500,000 per contravention. Corporations face fines of up to $10 million, 3 times the gain, or 10% of turnover, whichever is the highest. An individual may be disqualified from managing a corporation if found to have contravened the anti-cartel provisions. There are also a range of other remedies under the law, such as payment of compensation to victims of cartels, injunctions, adverse publicity orders, and other appropriate orders that the court may make. The ACCC has 2 policies it applies in relation to cooperating parties in civil matters. The ACCC's immunity policy provides conditional immunity to the first eligible applicant who cooperates with the ACCC. The conditional immunity applies to ACCC-initiated civil proceedings. The ACCC receives all applications for immunity and leniency. It's responsible for making a decision on whether to grant immunity from civil proceedings for cartel matters under the immunity policy and leniency from civil proceedings for enforcement matters under the cooperation policy. The Commonwealth Director of Public Prosecutions, the CDPP, is responsible for granting immunity from criminal proceedings for cartel matters. The CDPP's decision is based on a recommendation from the ACCC. The ACCC's cooperation policy for enforcement matters applies more broadly to the ACCC's competition and consumer protection activities. The cooperation policy applies generally to ACCC enforcement matters. In the cartel context, if one party has immunity under the immunity policy, a second or subsequent applicant may be considered for lenient treatment under the cooperation policy. Australian law now forbids corporations from indemnifying their employees for penalties flowing from their involvement in cartel conduct. Any application for immunity that the ACCC grants to a corporation will extend to any named current or former directors, officers and employees of the corporation who also request immunity. Those people must also satisfy the relevant requirements under our policy. The ACCC may also extend derivative immunity in respect of corporations that are wholly or partly owned or controlled by the immunity applicant. Derivative immunity provided to an individual as a current director, officer or employee will continue even if they leave the corporation. However, if an individual fails to comply with their obligations, the ACCC may revoke their immunity. The ACCC may then use their statements or information in any civil action against that person.
In the international cartel enforcement arena, a noteworthy difference among jurisdictions relates to whether individuals face personal legal exposure, and in particular imprisonment, for cartel conduct. In fact, this may be the most significant remaining difference among jurisdictions that treat cartel conduct as a serious legal infringement, a difference that affects the scope, operation, and incentive structure of leniency policies. Under United States law, individuals who are convicted of cartel conduct can face up to 10 years in prison and a fine up to $1 million. Although last year, for a combination of reasons, there was a reduction in the number and length of prison sentences imposed on cartel violations in the United States, the overall trend in recent years is one reflecting an emphasis on pursuing individuals criminally, with greater numbers of individuals prosecuted, longer periods of incarceration, greater frequency of imprisonment. The DOJ's leniency policy provides the ultimate protection for companies and their employees that choose to self-report a violation before an investigation has begun. No criminal prosecution, no conviction, and no fine for the company, and non-prosecution for all of the company's directors, officers, and employees who admit their involvement in activity with candor and completeness and provide full, continuing, and complete cooperation to the Antitrust Division throughout its investigation. If the threat of incarceration of business executives is the greatest deterrent to cartel conduct, then the promise of immunity from criminal prosecution and no prison for those executives is the greatest incentive for coming forward and self-reporting. In conclusion, in my own experience, both in the government and private bar, the Antitrust Division's premise has been vindicated time and again. For undertakings and individuals alike, the threat that individuals will be imprisoned is a game changer that causes organizations and individuals to focus in a more serious way on avoiding cartel conduct, or if the conduct has occurred, to take advantage of a leniency policy, come forward, report the conduct in the hope of executives avoiding jail.
Having weighed up all the pros and cons of the situation, my company has decided that we definitely should go ahead and apply for immunity immediately.
Right. Good. Yeah, that would be very good. Okay, we will check if immunity is still available and send through an application for a marker.
Sorry, there's one thing I'm still not totally clear on. I know you've explained it to me in detail, but could you please repeat? What happens with the information we have sent to an authority in one country? Is it then shared to other authorities? And how do these authorities cooperate with each other?
Competition authorities do cooperate with one another, insofar as they are permitted to do so by law in their efforts to combat international cartel behaviour. Many cartels are transnational in scope, and so it is inevitable that sometimes more than one competition authority may be interested in taking action against the same cartel. Cooperation may be particularly valuable where it can take place prior to the launch of surprise inspections on the alleged cartelists. The European Union has entered into formal arrangements with a number of competition authorities for cooperation in international competition law enforcement, for example with the United States, Canada, Korea and Japan.
As for international cartel cases, it is not rare that an enterprise concerned submit the immunity application to competition authorities in multiple jurisdictions at the same time. In that case, cooperation between competition authorities may take place. One of the typical schemes is designing investigation strategy. When the investigation is still covert, competition authorities put a big emphasis on gathering and preserving evidence as much as possible while preventing cartel participants from destroying evidence. Competition authorities exchange their views about, for example, date, time, persons, and places to conduct their investigations. To make it fully effective, it may be necessary to exchange information obtained from the immunity applicant. In this phase, waiver plays a significant role. Waiver given to a competition authority by an immunity applicant enables the authority to provide with other authorities not only the identity of the applicant, but also the specific information submitted from the applicant. Generally speaking, if not waiver, competition authorities may not be allowed to make such information provision because the identity of the applicant and specific information of the applicant are considered to be a secret of enterprise in many cases. Violation to confidentiality obligation is subject to criminal or administrative penalties in many jurisdictions. It is true that without waiver, competition authorities could exchange general information such as the outline of the alleged violation because such kind of information is not considered to be a secret of enterprise. However, it is also true that there must be quite a few international cartel cases where such general information exchange is not sufficient to make the investigation successful. Therefore, I would like to say again, waiver from the immunity applicant plays a pivotal role at pre-inspection stage. Lastly, but not the least, once the immunity is obtained from relevant competition authorities, cooperation between the authorities will not place the applicant to the worst position, putting in other words, never undermining the position of the immunity applicant.
A specific additional point worth noting is that within the European Union, cooperation also takes place between the European Commission and all the national competition authorities of the member states within the context of the European Competition Network.
As you know, anti-cartel fight is considered the #1 priority by most, if not all, members of the European Competition Network. ICN members have realized quite early on that putting national leads together was an efficient way to detect cartel cases of European dimension. And the car glass case of 2008 is one of the most convincing examples. Among all tools at the disposal of competition authorities, leniency programs have played a key and fast-growing role. Only 4 ICN members had such a program a decade ago. Today, 26 of them have adopted this tool. The adoption of leniency programs has received strong political support, both at national and European levels, which has undoubtedly fostered convergence and consistency. the ICN Model Leniency Programme of 2006, co-drafted by the French authority and the UK Office of Fair Trading, played a crucial role in this respect. This Model Leniency Programme helps prevent a discrepancy between national leniency programs by setting up a framework of substantive and procedural principles that ensures a convergent handling of applications across Europe. This, in turn, also encourages applications at the national level. Is the today situation ideal? Certainly not. We need continuous improvements. For example, in multi-jurisdictional cases triggered by leniency applications before either the European Commission or one or several competition authorities, reallocation is a sensitive matter because each ICN member will strive to preserve the position of the applicant and the attractiveness of its own leniency tool. Special attention must also be given to the exchange of information in relation with leniency applications. Another aspect of the issue is the mechanism of summary applications. It is a short leniency application form that can be addressed to national competition authorities under the ICN model program when a leniency application is filed primarily with the European Commission. It is intended to protect the position of leniency applicants at the national level while a decision is being made on an allocation between the European and national levels. Today, most competition authorities use summary applications. This mechanism, however, does not address all types of reallocations, and this is an issue that we are working on. ICN members also reflect on ways to coordinate national laws as to better protect leniency documents from third-party disclosure. But this is eventually something that national legislators will have to decide. Looking back, I think that Europe has leapt into a modern, consistent and efficient system of leniency programs. We will make every effort to improve it even further in the future. But looking back, I'm convinced that what we have made together is one of the best examples of a fast-growing and fruitful cooperation mechanism.
So, now we have heard about some of the important questions that members of the European Competition Network have to consider. There are others, of course. One, for example, is the complex relationship that exists between systems that treat the cartelisation of markets as a criminal offence and so-called administrative systems, such as that of the European Commission, that use an administrative model to enforce the law against cartels. Another complicated issue is the relationship that exists between the rules that provide for the enforcement of the law against cartels and civil law claims for damages brought by the victims of those cartels. Let's now move to a different issue. Most competition authorities investigating cartels will begin the process by conducting dawn raids.
Hello, will the companies under suspicious? Please call your
Just a second.
boss.
Hi, there's someone to see. Okay, please go to the second floor.
We can check, but I'm pretty sure. Hello.
This inspection is taking place because your company is under suspicion of being involved in a cartel. As your lawyer, I need to know all the facts.
Well, obviously we talk to each other. We run into each other all the time at conferences and things. This is a small world. And yes, we talked a bit about prices.
Okay. Well, if that's true, you might wish to consider cooperating with the competition authority. We can check, but I'm pretty sure that full immunity is probably no longer available. But such cooperation could potentially reduce your fine.
Much of the discussion so far has been about immunity, situations where a firm is totally exonerated from any penalty in return for bringing the existence of a cartel to the attention of a competition authority. However, it's important to understand that there are also circumstances in which a firm may, in return for cooperation, be given a reduction in its penalty as opposed to total immunity. As a general proposition, the obligations of a leniency applicant seeking a reduction in its penalty are similar to those of an immunity applicant. However, it's always important to look at the rules of any particular system to understand precisely what may be available to a leniency applicant. What we are going to do now is to hear speakers from the European Union, Japan, the United States and Germany, and we will notice quite a number of specific features about each system and how reductions of penalties are determined.
Under the Commission's 2006 leniency notice, companies that do not win the race for full immunity but still cooperate with the Commission's investigation may benefit from a reduction of fines that would otherwise be imposed on them. In order to qualify for such a reduction of fines, the applicant has first to disclose its own participation in the cartel, secondly, fully cooperate with the Commission, and thirdly, contribute to the Commission's ability to prove the infringement by supplying new, valuable evidence. Let's first see what the cooperation conditions are. They are basically the same ones as for an immunity applicant, except for the coercer test. This means that the leniency applicant has to cooperate with the European Commission, generally, fully, and on a continuous basis, from the time it submits its application throughout the administrative procedure. He should also terminate its involvement in the suspected infringement immediately, unless the Commission agrees otherwise, to preserve the integrity of the inspection, and he should not destroy, falsify or conceal evidence of the alleged cartel, and also not disclose the existence and content of its application except to other competition authorities where parallel applications are made. In order to qualify for reduction, the new evidence provided by the applicant needs to represent significant added value compared to the evidence already in the Commission's file at the time of the submission of this new evidence. In practice, it means that evidence submitted by an applicant has so-called SAV, significant added value, if it strengthens by its very nature and its level of detail the Commission's ability to prove the alleged cartel. The choice of the concept of SAV as a threshold for reduction of fines encourages the race between cartelists to cooperate, since the chances for the next applicant to add SAV to the investigation considerably diminishes with every new submission. Moreover, the reward for cooperation depends on the order in which the successful applicants meet the SAV threshold. The first undertaking to provide significant added value will be granted a reduction within a band of 30 to 50%. The second one will get a reduction within a band of 20 to 30%, and subsequent companies may get a reduction of up to 20%. You see that, contrary to other anti-cartel enforcement regimes, there is no limitation in the European Commission's leniency program as to the number of undertakings applying for a reduction of the fine and benefiting from such a reduction. But the later you come, the more difficult it is, of course, to still provide significant added value and to get indeed your reduction. Therefore, companies who consider cooperating have every interest to do so as soon as possible. The exact level of reduction within a given band is determined at the very end of the procedure and depends on the time at which the evidence was submitted, so the timing of the cooperation, and the extent to which the submitted evidence represents significant added value. In other words, the quality of the evidence and the cooperation. How does the Commission carry out its assessment in this regard? A guiding principle in that respect may be to consider to what extent the applicant provided the 5 W's of the cartel: who, what, when, where, why, and to complete the picture, one should also add how. In practice, there are several elements, between others equally important, that the Commission takes into account. Contemporaneous evidence, such as minutes of cartel meetings made at the time of the infringement, has a greater value than evidence subsequently established, such as statements of facts made at the time of the application. Incriminating evidence directly relevant to the facts in question, such as internal minutes of a phone call showing an agreement on price, will generally be considered of greater value than evidence of indirect relevance, such as a record that the phone call took place. Evidence which can prove a fact on its own, without requiring corroboration from other sources, will have more value than the evidence which has to be confirmed or backed up. The Commission will find more valuable, compelling standalone evidence than, for instance, a corporate statement uncorroborated by other pieces of evidence. Finally, if an applicant provides compelling evidence that increases the gravity or the duration of the infringement under investigation, the Commission will not take these additional facts into account when setting the fine for that undertaking. We call this partial immunity.
The Japan Fair Trade Commission, JFTC for short, levied surcharges against enterprises participating in cartel. If leniency applications are made after the investigation is started and they meet requirements, JFTC makes its decision, 30% reduction of surcharges. This rate of reduction of surcharges is the same for all the successful applications. Let me explain major requirements. First of all, deadline of the application for the reduction of surcharges shall be the day that is passed by 20 days from the investigation starting date. Secondly, companies shall submit a written report which is called Form Number 3 with relevant materials to the JFTC by the deadline. In Form Number 3, a company must write down a description of the act, a period of the act, names and positions of individuals involved, and how they implemented the act. It must be written down in Japanese language, and if the discovery procedure in other countries is at issue, a company may substitute an oral reporting for substantial parts of Form Number 3. For the application to be accepted, Form Number 3 must be submitted by facsimile. No other methods are accepted. This limitation is only applied to Form Number 3 reporting. So, documentary evidence can be submitted by other methods, such as direct delivery, registered mail. However, if 2 or more companies apply for reduction, the order of application shall be determined according to the order of submission of Form Number 3. There is a limitation on the number of the application. First, the total number of applications before and after the investigation is started is no more than 5. The number of applications after the investigation is started is no more than 3. For example, if the applications are made by 3 companies before the investigation is started, the rooms remain vacant are only 2. Likewise, if the JFTC receives 4 applications before the investigation is started, only 1 company will successfully apply for reduction of surcharges. The information from the applicant must include the facts other than those already ascertained by the JFTC. Unlike other jurisdictions' leniency programs, there is no consideration of the authority about the degree of added value as evidence. Finally, since its inception in 2006, the JFTC leniency program has made a great success.
As is widely acknowledged, transparency and predictability in how enforcement authorities will treat companies and individuals that self-report and cooperate is very important to the success of cartel enforcement regimes in individual jurisdictions, as well as cartel enforcement globally. This is obviously true for a company that is the first to report a cartel, and thus may be eligible for complete immunity from fines under applicable leniency policies. But predictability is just as important for companies who are considering reporting and cooperating when another firm already has secured leniency and thus 100% protection from fines is no longer available. Enforcers take varying approaches to providing prospective second in, third in, fourth in, and so on cooperators with an indication of how their cooperation may translate into reduced fines. The European Commission, of course, has promulgated an approach followed by many jurisdictions, namely, establishing as an official component of its leniency policy particular fine discount bands. The US DOJ, by contrast, does not have a stated policy setting forth discount bands. Indeed, the official leniency policy does not even affirmatively address how cooperators who come in after immunity has been granted will be treated. However, the U.S. does have a sentencing system that utilizes very detailed and highly structured sentencing guidelines and an enforcement practice of resolving fines and other aspects of criminal dispositions through plea agreements. In the last 25 years, more than 90% of defendants charged with criminal antitrust offenses chose to enter into plea agreements with the United States Department of Justice Antitrust Division. Since in the United States cartels are criminal offenses, the United States sentencing guidelines are the starting point for determining a company's fine for a cartel violation, just as is the case for all other criminal offenses. The sentencing guidelines, a 600-page instruction manual for how to compute sentences for organizations and individuals for all types of crimes, have specific rules for antitrust offenses. To summarize those antitrust rules briefly, the company's base fine is generally 20% of the volume of U.S. commerce affected by the cartel during the entire duration of the cartel. The base fine is then multiplied by minimum and maximum multipliers corresponding to the company's culpability score, which is based on factors such as number of employees, the involvement in or tolerance of the offense by high-level personnel, the company's prior criminal history, any obstruction of justice by the company, and the company's cooperation and acceptance of responsibility. The sentencing guidelines methodology typically yields a range where the maximum fine for any defendant is double the minimum fine. For example, minimum $200 million, maximum $400 million, or minimum $500 million, maximum $1 billion. However, the sentencing guidelines have a provision that on the motion of the government only, companies can receive reductions in fines to levels below the so-called minimum guidelines fine, referred to as downward departures, if the companies provide cooperation and significantly advance the investigation. It is at this point that the U.S. system becomes a hybrid, as the determination of a defendant's fine transitions from a computation that is formula-based to one that accommodates discretionary reductions, ranging from a few percentage points to, in rare cases, more than 50%, based on the government's assessment of the timing and value of the defendant's cooperation, as long as the ultimate fine is approved by the court. I often get the question whether, in the absence of published discount guidelines, counsel to potential post-immunity cooperators are able to make informed, reliable predictions of how a client may benefit if they come in second, third, or fourth place. The answer is unequivocally yes. While the U.S. approach is different, it provides experienced counsel with the ability to predict, with considerable accuracy, how later arriving cooperators will be treated. This predictability is true because the U.S. approach is based upon two important practices by the Antitrust Division. The first is a commitment by the division to negotiating proportional resolutions with comparably situated parties. Proportional not only among defendants in the instant matter, but also across matters and over time. The second practice is transparency, which enables the private bar to observe the way the Department of Justice is applying its policy of comparable treatment and how the DOJ has arrived at the discounts from sentencing guidelines given to defendants for cooperation in various circumstances. Before concluding, there's an important observation to be made. In comparing the U.S. approach with the EC and comparable approaches, it is useful to remember that the fact that the U.S. prosecutes individuals adds a wrinkle to the process. The Antitrust Division regularly insists on carving out from the company's protections in the plea agreement a certain number of individuals who will then face criminal exposure and be required to deal separately with the government. Companies that come in earlier and provide more valuable cooperation will see fewer executives carved out for jail sentences and will also see those executives receive shorter periods of incarceration. In conclusion, predictability and reliability depend entirely on overall consistency and coherence of decisions enforcers make. Whether one is looking at fine discount bans, stated fining guidelines, sentencing policies, plea agreements, or speeches, the basic lesson we all know repeats itself. Actions speak louder than words.
In 2006, the Bundeskartellamt introduced its new leniency program. It is today one of the most successful leniency programs of the world. One pillar of this success story is the marker system. The application process always starts with a marker, be it an application for immunity or an application for reduction of fine. The timing of the placement of the marker is decisive for the status of the application. The marker can be placed verbally and in writing, in German or in English. The marker can also be placed during an ongoing inspection. This is what very often happens. Applications may come in within minutes. The marker must contain details about, first, the type and duration of the infringement, second, the product and geographic markets affected, third, the identity of those involved, and fourth, at which other competition authorities applications have been or are intended to be filed. The Bundeskartellamt immediately confirms to the applicant in writing that the marker has been placed, stating the date and time of receipt. Besides, the Bundeskartellamt sets a time limit of a maximum of 8 weeks for the drafting of an application. In his application, the applicant must submit information which makes a significant contribution to proving the offense. All evidence gathered during an inspection will not be considered as evidence submitted by the applicant. Documents proving the infringement should be presented if available. If no such documents are available, it might be sufficient to name the employees involved in the cartel agreement and willing to appear for an interview and to testify the information. The application can also be filed verbally and/or in English. If the Bundeskartellamt accepts an application in English, the applicant is obliged to provide a written German translation without undue delay. The Bundeskartellamt initially only informs the applicant of his ranking and that he is in principle eligible for a reduction. This is due to full and continuous cooperation of the applicant with the Bundeskartellamt. A decision on a reduction is made at the earliest after perusal and examination of all the information and evidence obtained by an earlier inspection and/or by other leniency applicants. In most of the cases, the Bundeskartellamt informs the applicant after having filed the statement of objections on the concrete amount of the reduction. The Bundeskartellamt can reduce the fine up to 50%. The amount of the reduction is based on the evidentiary value of the application and its ranking. The ranking of the application is of essence, but it is only one element for the Bundeskartellamt to be taken into account. There have been cases where an application with a lower ranking but better evidentiary value got a higher reduction than an application with a prior ranking but poor evidentiary value.
Obviously, a firm that makes a leniency application to a competition authority is incriminating itself by doing so. It's admitting that it has taken part in illegal behaviour. We've been hearing about the kind of evidence that it will have to provide to the competition authority. Let's now hear about the making of corporate statements from the European Commission's perspective.
A corporate statement is a detailed description of the applicant's knowledge of the cartel prepared specifically for the purpose of the leniency application. Given their role, corporate statements must contain detailed information on the key elements of the cartel. For example, its purpose, the companies and individuals involved, and the description of the conduct at stake. Other types of information, such as financial data, corporate information, or business secrets, should be excluded from corporate statements. The European Commission accepts both written and oral corporate statements. Let me remark that from our perspective, they are both equal in terms of their probative value, their treatment during access to file, and the determination we will show in protecting them against disclosure. However, the applicant may feel more comfortable to give an oral statement in a situation where it fears private damages claims. In practical terms, delivering an oral statement requires that the applicant, usually represented by its legal counsel, comes to the Commission to dictate the statement and have it audio recorded. Such an audio recording is further transcribed and verified by the lawyer for its accuracy. What is important here is that both the recording and the transcripts are Commission documents to which access is strictly limited. During the access to file, the parties to the proceedings will get full access to both written and oral corporate statements. While such access guarantees their rights of defense, it is granted only at the Commission premises and no copies can be made. This is all to ensure that the Commission keeps control over corporate statements and that they do not become public. The reason for our practice is that, as mentioned earlier, third-party litigants may seek to access to corporate statements made pursuant to leniency applications. In this context, it must be stressed that the successful leniency program must sufficiently reassure potential applicants that corporate statements will be protected from disclosure. Otherwise, the disclosure of such voluntarily provided statements could seriously undermine the effectiveness of a leniency program and the fight against cartels. In particular, while the right to compensation cannot be ignored, entities that cooperate with the competition authority cannot be put in a worse situation in respect of civil claims than cartel members which refuse cooperation. Furthermore, owing to the mutually reinforcing nature of public and private enforcement, it is in the best interest of, on the one hand, the public enforcer, and on the other hand, private litigants, that corporate statements are well protected, since it is owing to the effective public enforcement that private damages actions are made possible and become more common.
I think we have learned by now that the design of any leniency system needs to be thought through very carefully. We have to create maximum incentives for firms to blow the whistle or to apply for leniency, and we also have to avoid any disincentives. Let's think of some particularly important points. The first is that it should be possible for a firm to obtain automatic immunity rather than this lying in the discretion of the competition authority. The second is that competition authorities ought to establish a marker system whereby a leniency applicant knows that it can preserve its position in the queue. A third very important point is that the leniency applicant will wish to know that any statements that it makes will not be disclosed either to another competition authority or, for example, to third parties without the consent of the leniency applicant. Another point is that it has been discovered in practice that it is desirable to allow leniency applicants to make their statements orally rather than in writing. This can be very important, for example, in the event of a court seeking discovery of written documents. Two final points are worth making. The first is that it is sensible in practice to allow leniency applicants to approach a competition authority even after that authority has commenced an investigation. And the final point is that it is sensible to have a system in which a firm can make a hypothetical inquiry about how any leniency application might be dealt with in practice. So, we hope that this video has enabled you to understand better what a good leniency program would look like. And remember, an effective leniency program should mean fewer cartels and more competition.